Elizabeth, I see that we have a captioner on board today, which is fantastic.
Yes.
Which is great. I know that was something that we had talked about doing. And if it's after 10, which it is, I think if everybody is ready, then we are ready for Dennis to do the announcements.
Yes.
Great.
Great. Welcome Council on Access and Fairness members, liaisons, and members of the public to August 26th, 2022 meeting. Thank you for joining us. We are using Zoom with the goal to foster a more inclusive environment and effective meeting. If you'd like to comment during the meeting, please use the raised hand feature. To use the raise hand feature, by a phone dial *9 on your phone's dial pad to raise your hand, and to do the same to lower your hand. Please utilize this tool to virtually indicate that you would like to speak in order to help us to facilitate the discussion. Going forward, all COAF and committee meetings will be recorded and posted to the State Bar website. A final reminder that this is a video conference and to be aware of your surroundings behind you. For those using Zoom on a computer, when on mute, holding down the spacebar will temporarily unmute. If you're using phone to dial into this meeting, please be sure your computer's microphone is on mute in order to avoid audio feedback issues. While joining audio via computer, it is highly recommended if an individual loses audio, they can call in separately using the Zoom conference number. And if a person wants to see closed captioning during the meeting, they will need to click the up arrow next to the closed caption icon and then select the closed caption to view. Thank you.
Thanks, Dennis. All right, I'm going to go ahead and call the meeting to order. Elizabeth, would you like to take roll for us?
Yes. Ryan Harrison, Kristen Rosie.
Here.
Heather Anderson, Novella Coleman.
Here.
Sarah Good.
Here.
Michael Rhodes.
Here.
Sherlock Richards.
Here.
Angelica Salceda.
Here.
Stephanie Santoro. Sal Torres. Okay, so we do have quorum.
Thank you. Good. So we're right there for a minute. Okay. Wonderful. Well, welcome all of you. It is nice to see you all on Zoom. I look forward to a time, hopefully very soon, when we can see each other in person.
Before we move on, Judge Kristen, I just want to acknowledge, I think Judge Dulcich is here, our Judicial Council liaison, as well as I think Pam Enslin from California Law.
I don't see Pam on my screen.
Okay, maybe not. Okay.
Thank you, Judge, for being here as well. It's always nice to have you join us. We appreciate that. All right, so now is the time where we call for public comment. I'll go ahead and let members of the public speak if there are any. We ask that you limit your comments to 2 minutes. Do we have anybody that wishes to make a public comment at this time?
Hi, this is, hold on a second. Claire Salat has her hand raised. I'll allow her to talk.
Great.
Good morning.
Good morning, Claire.
Good morning, everyone. This is Claire Solat from the Legal Services Funders Network, and I'm delighted to join you. I'm actually particularly excited. It's the first meeting with this commission that I've attended. And the reason I'm here today is I want to highlight some very serious concerns many of us have with regards to what is currently going on with the Blue Ribbon Commission that is exploring the future of the bar exam. There is unfortunately a subgroup of members who are attempting to avoid consideration of licensing options, which would dramatically increase diversity and be responsive to applicants with disabilities, both temporary and permanent. Unfortunately, at the last meeting, no one from this group was able to attend. And so as a result, that voice was really missing. Several of the other members and State Bar staff reiterated the charge that that commission has been given in terms of considering diversity, equity, inclusion as priorities. And absent the voice of groups like this, which I'm delighted to see is dramatically more diverse than the Blue Ribbon Commission, I am very fearful that we will be stuck with the traditional multi-day memorization-oriented high-stakes exam, which we know creates tremendous barriers for folks that are not the traditional law school population that has the resources and the support to spend 10 weeks studying exclusively for a bar exam. And quite frankly, we all know that even in the best of circumstances, many people, such as myself, I am single-sided deaf, cannot perform well in that kind of environment. So I encourage you all to make your voice known. I hope the representatives from this group will attend the meeting on September 7th. My understanding is that one of your representatives is out on family leave, and perhaps someone else from this group might be able to step in his place. But right now, it's discouraging and very, very concerning that we may be stuck with a continuation for the next 10 years of solely an exam in a format very similar to the existing bar exam, which we all know has tremendous problems when it comes to recognizing the need for diversity in our bar and the needs of disabled applicants. Thank you so much.
Thanks, Claire. I appreciate your comments. I don't know about Ryan, but I will be there on September 7th. All right, is there any other public comment, Kimberly, that you can see?
No, no one else has their hand raised.
Okay, great. Thank you. All right. Then let's go ahead and move on to approval of the meeting summary and action items from our June 16th meeting. Are there any comments or edits to the meeting summary from our last get together? Seeing no hands or anybody wishing to comment, then can I have a motion to go ahead and adopt the meeting summary and action items from the June 16, 2022 meeting?
I'll move.
Thank you, Michael. And is there someone who wishes to second? Don't be shy. Thank you, Shalak.
I second.
Thank you, Shalak. Elizabeth, can you take a vote?
Anderson, Coleman,
Yes.
Good,
Yes.
Rhodes,
Yes.
Richards,
Yes.
Salceda,
Yes.
Santoro, Torres. Okay, motion carries.
Thank you, Elizabeth. Okay, let's go ahead and start then with an update from the Office of Access and Inclusion and other state bar groups. Elizabeth, do you want to
Yes.
lead us off?
Yes. Good morning, everyone. I'm Elizabeth Hom with the Office of Access and Inclusion. I first wanted to congratulate our incoming vice chair and vice chair for the 2022-23 term. And so our chair for the term will be Judge Kristen Rosie. Congratulations. And then our vice chair will be Michael Rhodes.
Thank you.
So the board appointed them at their July meeting, and their terms begin at the conclusion of the board's September meeting. So we're very excited to have them in our leadership for the coming year. I also wanted to provide an update. I think last time I mentioned that our office had been recruiting for several additional staff, and we're pleased that 3 staff joined us this week. So you'll see some new faces on in the squares this morning. We have Dennis Yee, Michael Chong, and Jennifer Zelnick. And so they, as you know, our staff have mixed portfolios of work in addition to our grants administration work. Likely they'll be participating in various DEI initiatives. So hopefully you'll have the opportunity to work with them soon. And then I also wanted to turn it over to Brady, who will introduce a new attorney from our general counsel's office who'll be working with us.
Hi, everybody. Nice to see everybody's faces this morning. It was nice last time to see a couple of you in person. So I'm excited to announce that we have been expanding our team finally at the Office of General Counsel. And as a result, we've had a chance to do some cross-training. So for the past couple of years, I've been the primary support person in the Office of General Counsel for the Office of Access and Inclusion. And one of our newer attorneys, Raul Duran, is going to be joining me on the Office of Access and Inclusion team. And specifically, he's going to be attending probably most COAF meetings going forward. So he'll be a familiar face to you guys, hopefully. Raul joined us. He attended UC Davis for both undergrad and law school. He studied biotechnology and somehow then made the switch to law school. During law school, he was a judicial extern for Justice Mariano Florentino Cuellar on the California Supreme Court. And then prior to joining us this spring, he spent about 4 years at the Simpson Thacher firm in Palo Alto, mainly doing various litigation type tasks. So Raul, I don't know if you wanted to just say a few words of hello, and then we'll sit back and watch the meeting.
Sure, I'll just say that I'm very excited to be working with all of you, and I can't wait to get to know you over the next few months.
Well, thanks, Raul, and thanks, Elizabeth, and thank you all for giving us a few moments.
Thanks, Brady. Thanks, Raul. So that's the staff Office of Access and Inclusion report.
Great. Well, welcome, Raul. Thanks, Elizabeth. So we're going to take some things out of order this morning to accommodate folks' schedule. And I think we're going to start. George, you're on the screen. I can see you, right? Yep, there you are. So I think we're going to start with Chief Trial Counsel George Cardona, who's going to talk a little bit about Rule 8.4.1.
Sure, thanks. Thanks for taking me, and thanks for taking me out of order. Appreciate it. If it's okay, I'll go ahead and share my screen so I can present on some of the data that I was asked to gather. So hopefully everybody can see that. I'm seeing nods, so I'll assume that that's the case.
Yes, we can see it. Thanks, George.
I was told you wanted an update on data on our cases and allegations under Rule 8.4.1. So we've pulled together the data for the first 7 months of this year. That's data on cases that were complaints that were submitted between January and July of 2022. And the data is as of the end of July, which is when the data was gathered. So to understand the data, we divide Rule 8.4.1 into 6 separate allegation categories. So we treat A1, A2, and then the subsections under B, each of those subsections as a different allegation so that we can track the data relating to each of those allegations. And so we have data on complaints that included an allegation, one of these 6 allegations. So that's how we've pulled the data. So a complaint might come in, if it contains one of these 6 allegations, it's categorized as containing that type of allegation. It may contain other allegations as well, not Rule 8.4.1, but nevertheless, that would be included. So this is simply looking at any complaint that includes one of these 6 allegations is how we're pulling the data. So with that in mind, based on allegations, this is what has happened to the complaints that have come in. So there's been a total of 97 allegations And that's not equivalent to 97 attorneys because that's looking at each allegation. And there are some cases in which multiple 8.4.1 allegations are made against the same attorney. So this is looking on an allegation basis. So this is the total number of allegations under 8.4.1 that we received during this time period and what happened to them. So you can see 65 or 67% were closed in intake, which means that an evaluation of the complaint by an intake attorney indicated that there was not sufficient factual allegations in the complaint either to state a claim, and this is essentially done applying the equivalent of a Rule 12b-6 in the federal system, or a demur standard, looking at the allegations in the light most favorable and drawing inferences in favor of a potential success on the allegation. But we also apply a secondary standard, which is even if they don't meet that standard, if they provide enough facts to suggest reasonable avenues for investigation that might develop the allegation, it would still move on to investigation. So that's the standard that's applied in intake. 12 cases or 12 allegations or 12% were closed in investigation, which means that after some investigation was done, it was determined that we could not proceed to discipline. There was not a reasonable likelihood of obtaining discipline on the allegation based on investigation. And then 20 or 21% remain open, which means they are moving through the system. All of those, I believe, are either still an intake being assessed or have moved to an investigation and are being investigated. So that's on an overall allegation basis. Then we can do the same thing. We looked at the same thing, breaking it down by allegation. So this is that same type of data divided by individual allegation. So you can see that by far the most allegations we receive are 8.4.1A1, which is an allegation that a lawyer has unlawfully harassed or unlawfully discriminated against a person on the basis of a protected characteristic in the course of representing a client or in terminating or refusing to accept representation. That's the one where we get the most allegations, and there you can see the data as to what's happened to those. Again, the column on the left is it was closed in intake. Column in the middle, closed in investigation. Column on the right for each allegation, remain open. So then the final slide we have, we looked at this by attorney. So rather than looking at allegations, this is numbers of attorneys who had one or more allegations under 8.4.1 against them. There's a total of 82, and this is where they are. So for 55 of those attorneys, the complaint that included these allegations was closed in intake. 11 were closed in investigation, and 16 remain open. So that's basically the data on what I understood you wanted, which was the numbers on the numbers of allegations and attorneys who have been the subject of allegations under Rule 8.4.1. So my understanding is that you want this on kind of a regular basis. I think I was told semi-annually. So a couple of questions for you, which is this what you want? Is there different data that you want? Are there other things you're looking for? Because depending on what you want, we can see if we can pull that data in a statistical form out of our system. And with that, I'll stop sharing and take any questions or comments.
Thanks, George. I really appreciate that. And it's really helpful information. I have a quick question. I think that this is the data that we were looking for, at least initially. One of my questions to you is do you believe it's possible to pull the 8.4.1A1 data in a way where we could see, are these allegations about discrimination or different treatment based on race or gender, gender identity, sexual orientation? Is there a way that we can break down that data? I mean, it could also be intersectional.
We don't have a way to pull that data In other words, we don't have entries in our case management system right now that reflect that. We would have to look at each individual case and review the individual complaint.
Okay.
If that is something that would be of continuing interest, on kind of a longer term, we can see about whether it would make sense to add data points to our case management system. It would require additional work because it would basically require the individuals who are reviewing the complaints to make an additional data entry into our data system. But if that is something that's of ongoing interest, that's certainly something we could look into.
That's something I guess, you know, as a group, my fellow co-op members, we could talk about whether that's something that we would like down the line. It occurred to me, George, just because that seems to be where.
Yeah, we don't differentiate by the particular protected characteristic.
Right. And that data might be useful to us. Anybody else have questions? I see, let's see, I can see Michael's hand and then I can see Sarah. So Michael, why don't you go first and then Sarah?
Well, Novella had her hand up, but
Oh,
I
did
think she
she?
then took it
Oh,
down.
I'm sorry.
Yeah, my question was the same as yours, so.
Great. Thanks, Novella. Great minds.
Thanks, George, for this. Can you give us a little bit of context when it comes to, I think it was about 90 different complaints in the 7-month period, whether that seems like a lot or a little compared to similar numbers for other types of complaints. And then in a similar vein, the proportion of the clearance rate or the proportion that are being closed at intake versus remaining open.
So I can give you some numbers that may put it in context. So typically in any given year, we receive somewhere between 12,000 and 15,000 complaints. And that's covering all of the various provisions of the rules of professional conduct and various state bar provisions. Of that, our typical closure rate and intake is somewhere between 80 and 90% over the year. So the closure rate that you're seeing here is actually slightly below our closure rate for our allegations as a whole, or our complaints as a whole in intake. In terms of by comparison, you know, this isn't anywhere near the most common of the types of allegations we get. The most common allegations we get are failures to communicate, failures to return files. Those are probably the two biggest. And then from there, it's highly variable in terms of what we get every year. I'm not sure there's a context that I'm not sure there's more context I could give to this. Does that answer?
That's helpful. Yeah, well, it's helpful. Thank you. I'm sure as we get more time behind us, there will be a little bit better understanding of how this compares to some of the others, especially on the back end for cases that remain open or that may move through the discipline process. Thank you.
Sarah.
I just wanted to say, so I know a little bit about this because of being educated through the ad hoc commission's work, generally about the disciplinary system. But I wanted to say, I think the concern was whether or not this particular provision was utilized and whether or not complaints were made about it. And it's clear to me from looking at this data that, you know, there's a robust number of complaints that have been raised in this fashion. And so I'm satisfied, and I would advocate that we don't need to have OCTC engage in this sort of manual examination of each individual complaint to categorize it into an area for us, which I think sounds like a lot of time and perhaps not all that beneficial. So I would argue that, you know, this format I think is fine for our purposes to understand that it's being utilized. People are aware of it. People are bringing complaints under it, which I think was, there was some suspicion about whether that was so when we asked for the data. Thank you.
Great, thanks, Sarah. And perhaps someone can remind me, Elizabeth, we tried to do some education around this too, didn't we?
Yes, that's right. I think working with George's office, our Office of Communications developed a consumer video to bring attention to the rule and point members of the public to the correct resources to file these complaints.
And if you haven't seen the very short 2-minute video, it's well done.
Yeah.
Great. Thanks. Well, I mean, I'd like to think that it's making a difference in getting allegations, in getting folks knowing that there's a resource out there. So, all right. Anybody else have thoughts or questions or comments about George's presentation? Scanning to see any hands. I don't see any. Okay, great. Well, I think, you know, going forward, this will be something that Co-op talks about, George, but I think right now, you know, this is the data that we were looking for, right? To Sarah's point, we wanted to make sure that folks knew this was out there, knew that they could make complaints, and that seems to be happening. So I appreciate all the hard work that your staff has done to get that data together for us. Thank you.
Sure, no problem. Thanks.
All right. Okay. Moving forward to 5D on our agenda. Elizabeth, would you like to update us on the Diversity Summit?
Yes. As you know, we typically hold a diversity summit annually. With the publication of our diversity report card, which you will receive a presentation on a little bit later this morning on, we would like to plan a diversity summit likely in October. I would like to ask if there are volunteers from the council who would be willing to spend some time on a working group to help us develop our agenda. Michael, Sarah, okay.
And I'm also happy to help, Elizabeth. Is it going to be sector specific or just an overall?
I think for this one, we will likely have one general one where we make the presentation about the diversity summit and then have sector specific breakouts. And then depending on maybe interest, we may plan maybe smaller events, into the new 2023.
Great. Great. Fantastic. Sometime in October, you said.
Yes, likely late October.
Okay. Great. Okay. All right. You got Sarah and Michael on that, right?
Yeah.
And myself. Good.
Yes.
Okay. Moving on to item 5E, the DEI Leadership Seal program.
Yeah, so I will just share one slide quickly. As many of you remember, the DEI Leadership Seal is a program that we are developing with the goal to encourage all legal employers to publicly commit to advance diversity, equity, and inclusion in their workplaces and thus in the legal profession. So we have been working with many of you, we had a working group and worked with many stakeholders in various sectors to develop 10 actions where we would ask employers to commit to and then implement 7 actions to become a participant in this DEI Leadership Seal program. As a reminder, the goal would be to make the action items more ambitious as the years go on, we hope to launch in the fall of 2022. This is the seal that we've developed. I don't think many of you have seen it yet, but I just wanted to give you that update that we'll be launching likely around the same time as the Diversity Summit.
Great.
So just a quick reminder about that. So thank you.
Thanks, Elizabeth. And I cannot recall who amongst us was on that working group, but if you were, thank you for your hard work. And I like the little seal. It's cute. It's a
Thanks.
nice little stamp. I like it.
And I'm sorry, I, for some reason, cannot stop sharing my screen. Okay, there we go. Apologies.
No, it's good now. All right, great. I am looking on my screen and I don't.
Erica has just joined us.
Oh, fantastic. Okay, I can't see her yet. Oh, there she is. Great. She just doesn't have her camera on. Okay, great. Erica, fantastic timing. As we are now on item 5H, which is the law school loan repayment program update.
Great, thank you. Good morning, everyone.
And I think, the last time we were all together, Erica, and I think you were there, we had a lot to celebrate. And so other than Elizabeth and I, folks probably, and Heather, folks don't know much about the update, so.
Okay, sounds good. Yeah, so here to give an update on addressing retention in the legal profession through law school loan repayment. As Kristen mentioned, at our last meeting, we talked a little bit about the Loan Repayment Assistance Program Working Group, which is comprised of members of COAF, the Legal Services Trust Fund Commission, California Access to Justice Commission, and State Bar staff. We've been working for probably almost the past 2 years, at least a year and a half, on understanding law school loan debt and researching the existing LRAP options that are out there, as well as possible ways to expand LRAP to attorneys, specifically to address recruitment and retention and diversity in the legal profession. So, at the time of the last update, we talked about what we did earlier this year, which was in March. There had been a preliminary proposal for a state bar supported loan repayment assistance program. And then in the ensuing months, we fleshed out that proposal a little bit more, worked with the working group, brought it to the legislature, and there was a lot of excitement about the possibility for specifically having a loan repayment assistance program geared towards civil legal aid attorneys in California. So at the time of the last COAF meeting, the status update was that it had been included, such a proposal was included in the legislature's budget, which would have had $55 million over a period of 5 years for loan repayment assistance, and it would have allowed attorneys to obtain up to $10,000 a year in assistance for repaying. Excuse me. And some of the benefits of this program were that it was also going to be tax exempt, so it was really going to maximize the benefit of loan repayment assistance. And there was a lot of excitement about this program. But as you can see on the slide, unfortunately, after that meeting, a short time later, Governor Newsom was reviewing the budget and he decided to exclude the program. And so it is not in the 2022-23 budget at this point. The working group has met another time to try to brainstorm some ways to salvage the program or reincarnate it in some way. We are looking into still obtaining some level of state funding, obviously not as much as what had been initially reported, unfortunately, but looking to maybe do a smaller program, smaller in scope, or smaller amount of funding, shorter period of time, something like that, to at least still move the program forward, show that it's effective, and hopefully get more buy-in in future iterations. So there is, as I understand it, some possibility that there may be still some state funding that could support an LRAP, but it's very much kind of uncertain at this point. We won't have a final answer potentially until October. So as I said, working on it, but sadly don't have a better update in terms of where we were back in June. Another alternative that we have discussed was that the Access to Justice Commission had also proposed that if state funding is not available, to start a program where employers will use some of their own funds to support their employees with an LRAP. So obviously that would be smaller in scale, but it would still preserve those tax benefits for the attorneys working with those employers. So that's another alternative, whether it's the Access Commission or another entity administering that program. But that would be the kind of like the last preferred option, but it is something that's on the table in order to try to kind of move this forward. So, but that's kind of the current status, is that we're a little bit in a holding pattern for the moment until we get an answer about additional funding.
Thanks, Erica. You know, obviously for COAF members, you know that this is something that that Heather and I have worked really hard on, and so have State Bar staff. And so we're not giving up on this. We believe in this program, and we believe that it's important to diversify the law school pipeline. So we're going to keep working on it, and COAF should keep working on it. And Dwan, I see your hand.
Yeah, I was just gonna say, I mean, we were all really disappointed. We thought it was a very, like, not sure, but very, very close to being a sure thing that would happen. So we're really disappointed. As Erica said, you know, there's just a really slim chance. We're not really counting on it, but our leadership, Donna specifically, has been in communication, and there's some funding at the governor's level. And the Legal Aid Association of California is going to try to do some advocacy again. We're going to try to do all we can. It's just a really, really slim chance. And that's why this alternative, we're hoping to salvage something this year and then go back to the legislature at some point next year or the following year to say, hey, listen, we have somewhat of a pilot up. There's an infrastructure now. Can you provide us with the funding? So I just want to thank Judge Kristen and Heather really for being engaged in this process. And we're going to continue to meet with the working group and hopefully have a better, more positive update at the next meeting.
Yeah.
We'll see.
Yeah. And again, you know, we none of this is possible without the State Bar staff. So really thank you all so much for your hard work. And for those of us who've been in state service for long periods of time, you know, getting close and then having things pulled from the budget is a way of life. And yet, you know, in my 26 years now of state service, it never gets any easier. You know, we will keep working on it, and COAF will keep working on it until we get something meaningful. So thank you all for all your hard work on that. Does anybody else have questions that they want to bring to Erica while she's here still? And admit, I cannot actually see everyone because of the screen share. So, oh, Sarah, now I can see that Sarah has her hand up.
I was just going to echo Judge Kristen's, you know, thanks to the State Bar staff who, you know, really put together this incredible package. And you know, it's a long game, not a short game. So thank you so much for all of your hard work and creativity and innovation and patience. So thank you.
Thanks, Sarah. Anybody else have anything they want to add on the loan repayment? I know if Heather were here, she'd
Actually, Heather just joined.
Oh, yay!
That was a little bit of a shock, the last part.
Welcome, Heather.
Rewind.
Anything you want to add, my friend, about, you know, I don't know if you heard me say how disappointed we were. But.
Yes. Definitely disappointed, but not going to give up. We will continue the good fight. And hope to have, as everyone has said, a better report the next time we all gather. So.
Thanks.
And apologize, I'm traveling and moving around all at the same time, but you have my undivided attention now.
Thanks, Heather. I'm glad you're able to join us. Okay, Erica, it looks like you're up next on our agenda again. On the implicit bias MCLE.
Yes, so just a quick update on the online 1-hour implicit bias course that was developed in consultation with COAF and with the support of COAF. As you know, it's meant to conform to changes in the state bar rules and the Business and Professions Code that created this new sub requirement within the elimination of bias MCLEs. And so this is the first kind of official focus on implicit bias to course to conform to these new requirements that are going into effect with the next reporting period. So we've started at a good time to, catch anybody who may need to take this course when they're reporting in early 2023. So when I gave this update 2 months ago, the course had only been running for about 4 months, I believe. And so just kind of giving you an update on the numbers here. At the last meeting, we had about 1,300 participants. Our most recent reading was almost 1,900 individuals had completed the course. So still seeing kind of steady and good numbers. One thing that we're a little disappointed to see, but is consistent from my last report, is that the survey response rate is still fairly low. It's only at about 28%. And so, I think we still need to brainstorm some ways to maybe increase participation, because we would like feedback from the whole spectrum of participants. And I think what we're seeing now, which is maybe not unusual, but is, folks who really liked it or really didn't like it. And so we want to kind of see a better representative sample of individuals participating in the course. So that's something I think we'll be working on in the coming months, but pleased with the participation thus far. And I think I mentioned last time that I would expect to see higher numbers closer to the end of the year when the reporting period is coming up. And so hopefully we'll kind of generate some more interest in the next few months as well. This first scale, there's 5 rated questions and then 2 narrative questions in terms of feedback at the end of the course. And so this first question was, to what extent did the course meet your expectations? About 80% of folks rated it a 4 or a 5, 4 or 5 being the best or the highest. At the last meeting, it was 79%, so it's hovering around the same numbers. This is the metric that we will also be reporting out to the Board of Trustees when they review course outcomes. So looking pretty good there. The second question was, to what extent the course contained significant practical content? Again, it's a slight improvement over the last report, but it's around the same. I think here we had 76%, and last time it was about 75, rating it a 4 or a 5. To what extent did the course provide helpful information? We're at 70, 72, 73%. And so again, it's actually improved over last time. I don't have an update on the narrative responses. I think I went over some of those at the prior meeting, and we talked a little bit about ideas that folks who took the course had for new courses in the future, wanting to see more of this content. What we're also seeing in terms of complaints is folks don't really like the having to listen to the narrator the whole time. They'd prefer to move at their own pace. We've gotten a few reports about some technical issues, so we're also going to look into that to make sure that it's running smoothly, because we want folks to feel encouraged to be using the portal and using this course, and not being distracted from the content with any hangups. So that's another thing that we'll be working on. But like I said, most of the responses are consistent so far, and I think it'll be interesting, because we've only had 2 months since my last update. It'll be interesting to look back on this once we've gotten, several more months under our belt, so to speak. So look forward to doing that comparison in a future meeting. But that said, on that update, I don't know if anybody has any questions about the course or the feedback we're getting.
I think Novella has her hand up.
Mm-hmm.
Yeah. I don't know if this would be administratively feasible, but one way to assure more people do the surveys is to not send them their CLE certificate until they completed.
I'll look into that.
That's how the California Judicial Council Court trainings go. We have to do the survey first and tell them what you think of the survey. And it's not a short survey. Judge Dolce is nodding her head as well. It's not a short survey, but before you get the certificate that says you finished, you have to do a survey. So that's not a terrible idea, Novella.
So I also, just picking up on what Erica said about, looking more at the evaluations. I wanted to know if COAF members were interested in forming a working group to, work with staff to look at the evaluations and then consider additional areas for perhaps developing an additional implicit bias training module.
It's a fantastic idea. Anybody interested in being on a working group that would look at those answers? And see Novella's hand is up. Fantastic.
Great. If folks decide later, please feel free to reach out. Oh, and that's Angelica.
Angelica's hand is up.
Thank you.
And thank you, Erica, for all of that. Appreciate it.
Thank you.
Okay. Elizabeth, do you want to talk to us about the early pipeline?
So as you all know, I believe it was now a year and a half or 2 years ago, we developed an outreach video featuring general counsel from the Golden State Warriors as a piece that perhaps high schoolers and community college and college age students might be interested in to pursue a legal career. And we were hoping to develop another video this summer. Unfortunately, we've hit a bit of a snag there. And so that video will be delayed. So I will be convening the working group to discuss our options. And just as a reminder, our working group is Sarah, Ryan, Heather, and Kristen. So I will be reaching out to you in the next several weeks.
Great. Thanks, Elizabeth. Okay. And I think you're going to update us a little bit on the licensee resource page too.
Yes. So in the board's 2022 to 2027 strategic plan, there are plans to develop a licensee resource page acknowledging that attorneys face challenges that may impact competency, that where the state bar could provide resources before they are in our discipline system. And so instead of being reactive, I think the goal is to be proactive by providing resources to attorneys. And so our Office of Professional Competence will be leading this effort. And so I know that we had the imposter syndrome presentation last meeting, and I think we will definitely be convening the working group before the year end to work with staff, including staff from the Office of Professional Competence, to get that underway. The resource page will include resources beyond those for imposter syndrome, and so I think it is going to be a very exciting. It's going to be very exciting work to come. So I know we have a working group, Shalak, Stephanie, and Ryan. And so I just wanted to give you that quick update and let you know that I appreciate your patience in us on the staff side, kind of getting everything ready to move forward on with that work.
Thanks, Elizabeth. All right. DEI resolution.
So I'll take that one too. Thank you to our working group, Shalak, Michael, and Kristen. We met a few weeks ago to talk about the ABA's DEI resolution, whether it would be appropriate for the state bar perhaps to adopt something similar. We reviewed similar resolutions and rules from the other 50 states and including Washington, D.C. to see what other jurisdictions are doing. We didn't see that there were any rules, like rules of professional conduct, that included a DEI requirement that the ABA's resolution was suggesting. And so, and the working group thought that, perhaps it was appropriate that the state bar see if it could develop a rule or something similar. And so, and we also looked at pro bono rules and resolutions, as we thought that might be a similar or a comparable area. And so for the state bar, in our rules of professional conduct, there is commentary related to pro bono work to encourage pro bono work, but there is no requirement. And so we are looking into whether the rules of professional conduct could be revised to include some similar language related to diversity, equity, and inclusion in the commentary. So we are seeing what the possibility of that is, and we'll likely need to work with the Supreme Court on that. And so when we have more information about that, I will reconvene the working group to talk through what our options are.
Great. Thanks, Elizabeth. Anybody have questions about that work? Okay. Elizabeth, I know we are a little ahead of schedule. And I don't see Natalie, but I do see Crystal. Do you want me to
why don't
or
we
maybe take Judge Dolchitz out of order?
Yeah, why don't we do that? Judge Dolcich's.
Great. Fantastic.
So mine is really short. I really don't have an update for you all. We continue our work on the Judicial Council's Committee for Providing Access and Fairness. We've been working all summer. We had a couple missed dates, so that's why I don't have much of a report for you. But we are continuing in the same directions that I've mentioned at previous meetings. So again, it's great to be here and watch what the State Bar is doing in this direction as well.
Great. Thank you, Judge, and it's nice to have you here, and we appreciate that you are here at all of these and you stay for as long as you can. We really appreciate that.
No worries. Thank you.
Elizabeth, do you want to tell me where to go next?
So, so the remainder of our meeting, we're waiting for folks who had some scheduling issues this morning. So perhaps we can take like a 10-minute break.
Sure. I'm good with that.
With everybody.
All right, everybody, we'll take 10 minutes. Everyone can stretch, get more coffee, move around.
So we'll resume at 11:10.
Great.
Thank you.
Thanks, Elizabeth. Sorry, I'm moving too fast. Okay, welcome back, everyone. Hopefully everyone got up and stretched a little bit. Let's see. So
I believe Natalie and Crystal are here.
I can see them both on the screen. Excellent. Natalie and Crystal, we are hoping you can provide us an update on the law school retention study.
Crystal, would you like to start, or if not, I'm happy to chime in.
Yeah, Natalie, if you could take the lead, that would be great.
Great. Okay. Well, thank you, everyone. I appreciate the opportunity to speak with you directly. My name is Natalie Leonard. I'm the Principal Program Analyst for Educational Standards and Admissions, working with the accredited and registered law schools largely. So we've been working with Oriya and also with Crystal and Elizabeth to begin to collect expanded demographic data, as you well know. In the process of doing that, we discovered what we were looking for, but we also discovered that there is much more nuance to the data in the registered and accredited world. Examples include looking at schools that allow students to continue on to the second year while they're waiting for their first year law school exam results versus those that require or offer a leave of absence. And so we are taking the opportunity to look at some of these nuances related to the data. In the meantime, the rollout of the collection continues on. We've expanded our race and ethnicity collection. We've expanded the categories available in gender, and we do a plan to begin collecting self-identified disability and veteran status with the with the reports that we'll collect this fall that are generally turned in November and December. So we thought it was best to fully plumb the data and get all of the insights that are unique to this population, layered on with the additional effects of for this population regarding the pandemic, where we saw a lot of individuals who are not only working, but maybe caring for children who have alternate school schedules, caring for elders who have additional risk in the pandemic. And so we've seen somewhat of a little bit of a different pattern in their enrollment too. So those are some of the extra things that we are looking at in the data and looking forward to bringing to you in the future. I'd be happy to answer any questions you might have.
So I just wanted to add that based on Natalie's update, that means that the law school retention study report that we've been working on and that our working group had provided feedback on will be delayed. And so we are hoping to publish that with the enhanced data that Natalie described in 2023.
Great, thanks. Anybody have comments on Natalie's presentation? All right, seeing none, we can move on. Amy, I see you on the screen. Can you give us an update on the Blue Ribbon Commission?
Absolutely. Hello, everyone. Good afternoon. I'm Amy Nunez. I'm the director of the Office of Admissions. And that screen up there should say update on the Blue Ribbon Commission. So I apologize. The wrong screen went up there. So I want to give you an update since our last meeting. So last time I presented at the co-op meeting in June, I talked about all of the determinations that had been made, or a set of recommendations that have been made by the Blue Ribbon Commission, as well as remaining determinations that had to happen. So just to remind everybody, there are two separate sets of recommendations that are required. One related to an exam pathway and one related to a non-exam pathway. So where we're at now for the exam pathway, the commission has made these two recommendations related to the exam. What they did is made recommendations on the legal topics that should be included in the new version of the California bar exam. And so this slide covers what those content areas, 8 content areas would be, as well as the skills that need to be incorporated in that new exam. As you recall in our discussion, what we wanted to talk about was the fact that this new exam the intent is to make it less memory reliant. That is, memorization shouldn't be like a key skill that's going to be required for this. So the idea is to create something that's more interactive, realistic. And so in that process, these skills are going to be the ones that are going to be targeted. And again, these legal topics as well as the skills are those that were derived from the CAPA study. That's the California Attorney Practice Analysis that was conducted by California back in 2018. So what remains then for the exam pathway in this next slide is, the question is for those that, for an exam pathway, do attorneys from other jurisdictions need to sit for the full exam? So the considerations are, what alternatives are there for both out-of-state and out-of-country attorneys in order to become licensed in California? This is a discussion that we're going to continue at the Blue Ribbon Commission. And some of the options that have been discussed are looking at admission on motion, which is the ability to get licensed without having to sit for a bar exam. Usually that is contingent and based on years of experience, and some jurisdictions have that in place right now. And what we're going to talk about also is the uniqueness of California. Many of these jurisdictions also are on, there's about at least 34 that are on the uniform bar exam. And so one of the things that's allowed, given that they're in the UBE, is the ability to port their score. So the score that they get on their UBE, to take that score and bring it to another jurisdiction. Obviously, that's not feasible for California because we're not on the UBE. So we have to rely on something like reciprocity or comity. And reciprocity is where one jurisdiction allows another jurisdiction admission on motion, as long as that jurisdiction, it's mutual. That is, both jurisdictions allow admission on motion. Comity is where a jurisdiction allows somebody to sit in regardless of whether that privilege is extended to candidates from that jurisdiction. And so the idea is potentially like embarking on something like that, but it would require also other considerations, such as would California grant that only to those jurisdictions that offer it. Among also the considerations is that in many jurisdictions, reciprocity and comity are only offered to applicants or attorneys that have graduated from ABA law schools, American Bar Association regulated law schools. And as we have in California, we have other types of law schools. And that's going to be one of the considerations that the Blue Ribbon Commission will have to weigh in on. Next slide, please. So the non-exam pathway has a lot more that needs to get addressed. And we dedicated quite a few meetings to study this, because there's so many components to a non-exam pathway. So these are the questions that we have to tackle. Where the knowledge and skills going to be derived from in a non-exam pathway? Is it a curriculum that is obtained in law school? Does it happen after law school? What, if any, are the post-law school requirements? So, really, are these requirements like things that you get through law school doctrinal teaching? Are they part of an experiential curriculum? Like, do they do this like through clinics, simulation, externships? Is it the same curriculum or should it be different? So also in this, one of the considerations is this something that's open to all law school students? What happens also with those that are in the law office study program? So they're meeting the educational requirements, the legal education requirements to sit for the bar exam, working in a judge's chambers or with an attorney. What criteria needs to be met in order to qualify for this non-exam pathway? Would all the law schools have to have a curriculum that supports this pathway or not? And also, who selects the pathway for those California law students? Will there be a criteria? And much in the same way for the exam pathway, looking at what it means for out-of-state and out-of-country attorneys, or those that graduated from non-California law schools, foreign educated law students. Is there a path for them in a non-exam pathway, or is there room for them? Also, how to address the perception that a non-exam pathway is a second-tier pathway, and potentially the perception that these attorneys are less qualified. So it's a lot to tackle for this group, which is why we dedicated so much time to looking at this. Next slide, please. And what we've done to help the commissioners with make these determinations is we brought in speakers from programs that are currently active with a non-exam pathway. Either the program's been active or they're in a much more expedited planning process than we are in California, as well as scholars. So some of the scholars that we've heard from here are Deborah Merritt and Joan Howard. They've created and written significantly on alternative ways for testing for minimum competence outside of a bar exam. We heard from the Daniel Webster Scholars Honors Program. This is in New Hampshire that's looking, that uses externships as a way of their licensing. Wisconsin has come to present on diploma privilege. The Oregon Task Force recently developed and is finishing their plans for allowing a non-exam pathway, and they have different models of allowing for that, which include supervised visitation as well as supervised, I keep saying that, supervised practice, as well as experiential training as part of that process. And then we heard from Canadian provinces. We heard from three, so Alberta, British Columbia, and Ontario. And they came and presented at multiple meetings to cover the way that it's done in Canada. And they have both an exam and a non-exam pathway. So it was really interesting to hear from them so we can figure out like how their models could address some of the questions that this group is grappling with. Next slide, please. So, probably in May and in June, we were able to narrow down by looking at, like I said, the models as well as, coming up with potential models that could be applied to California. Commissioners were asked to rank order the models that seem most interesting. And the components that are very consistent in the rank ordering were these three. These would be essential components to a non-exam pathway. First is where it starts, and I'll get into that in a second. That supervised practice should be a component of a non-exam pathway. And lastly, assessment. An assessment is a way to ensure consistency and validity of the experience itself. It would ensure that there's some benchmark that needs to be met in order to evaluate that somebody has met minimum competence through a non-exam pathway. Next slide, please. So when we look at the components of law school, the question here is, what would that look like? And one option is that we do not change the way legal education is working right now. Because every law school type, whether you're in a registered law school, an accredited law school, or an ABA law school, experiential training is, or experiential education credits are part of the curriculum. So we would not change any part of that program. We would perhaps require the ones that meet the CAPA requirements on skills and abilities that I noted earlier. That would be one of the requirements, but we would not impose any changes to the current curriculum, as I noted here, that most schools already offer that as part of their regular curriculum. The other alternative is for law schools to expand their teaching so that they must modify their curriculum so that skills and abilities that stem from the CAPA assessment are incorporated as part of that. So that is what the commission is grappling with right now in terms of the law school components. Next item, please. And the next item has to do with supervised practice. Specifically, how many hours of practice should be required? Do they start in law school? Do they start post-graduation? And I think the most challenging part is this next part is some of the issues that were raised by the Canadian provinces deal with the disparity in the supervised practice, and some of that disparities that we also see in our provisionally licensed lawyers program here in California. And that is people who have access to a mentor, mentee, or a position where they get the supervised practice. There are equity issues, people who are more connected to law in general will have an easier time not only getting this job, but getting the oversight. And we see this play out, like I said, in our PLL program. We did a survey of those who did not participate, and identifying and having access to a supervisor as part of their practice was a big issue that was raised, as well as compensation and how to address all of these, like how to ensure that we don't create the inequity that we see with a bar exam as well in a non-exam pathway. Next item, next slide, please, is assessment. And here we have, we talked primarily about two options, but there are others, as you can see here. One is creating a summative like capstone or portfolio that would be provided at the conclusion of the supervised practice. And that would be submitted to a regulator, most likely to the state bar. And we would review and score that to determine whether it's met the minimum competence that we set out to tackle through the supervised practice. The other option is to create this California prep program. It's one of the Canadian provinces uses that now. What it is, it's something that we have to develop. They're online modules combined with some in-person work where people get more of the experiential training as well as some of the coursework that combines together with this. So you'd have like a simulated law firm, and you would have many assessments as you're going through this prep program. And so that would be combined with in-person capstone, so that people would be required to do some in-person work as part of this. And all of this would run concurrently with a supervised practice while they're in a supervised practice model. And lastly, the other models are open book assessments. So they're more mini exams rather than the full bar exams. And those would have to be definitely spec'd out in terms of what that content will be and how that would differ from a bar exam. So this is that third component that the commission is grappling with. And as you can see, they're very complicated. It's very complex and also a lot to tackle. I mean, when we looked at the other models, like I mentioned, New Hampshire and even the Canadian provinces, they don't have the volume of applicants that we do in California. So I think, the scalability is a big issue, and it's really been something that's challenged the committee to come to a consensus about. And this next slide, I'm going to share it, but I'm going to read the entire thing. So at our last meeting, we submitted we put out two proposed motions. They were both rejected or did not pass. And I'm going to read them to you just to give you a sense of all of the components and where the committee is at the moment. So here, the first proposal was the Blue Ribbon Commission recommends to the State Bar Board of Trustees and the California Supreme Court that California explore a bar exam alternative for licensure to practice law. It is recommended that this exploration of an alternative pathway have a significantly increased focus on assessment of knowledge, skills, and abilities for entry-level practice, de-emphasizing the need for memorization of doctrinal law. The precise elements of the bar exam alternative, including eligibility and time frame to completion, should be determined in consultation with experts, including psychometricians, to ensure the pathway is valid and reliable with a standard equivalent to the bar examination. It is further recommended that the alternative pathway shall include the following elements. One is law school, that any applicant interested in availing themselves of the alternative pathway would need to complete at least 6 units of experiential coursework in law school that covers CAPA skills and abilities. However, serious consideration should be given to increasing this experiential education requirement. And for supervised practice, the proposal was that there should be a post-law school supervised practice requirement. The exact number of hours required remain to be determined, with the goal of consistency with the exam timeline to licensure, so that no one would have to wait further than the 9 months or whatever it takes right now between the exam and the results release. Next, mandatory and structured supervisor training and oversight to be developed by the regulator shall be required in order to provide consistency in the supervised practice component and ensure that the supervision continues to emphasize the skills and abilities necessary for minimum competence. A to be determined percentage of supervised practice hours may occur during law school, and equity, disparity, and cost issues must be taken into account. And lastly, for assessment, a summative assessment may include a capstone portfolio, simulated in-person assignments, and/or a written exam component. Scoring and grading must be valid, reliable, and conducted by the regulator. So this was one of the proposed motions at our meeting last week, and it was rejected. And can we go to proposed motion B? And the next one is the Blue Ribbon Commission recommends to the State Bar Board of Trustees and the California Supreme Court that California does not adopt a non-exam pathway for licensure to practice law. It is further recommended that a bar exam alternative be considered after the implementation of a revised California bar exam. So that also was not successful, and neither of these received a sufficient number of ayes. And so both proposed motions did not pass. So clearly the group is somewhere in the middle. We're going to have more discussion at our September meeting to figure out where that consensus is and if there's anything else that we need to address. But at this point, we've really dedicated a lot of time, material, and speakers to all of these considerations. But as you can see, they're complex. And part of it is just trusting that this will work. And so with that, I just want to open it up to see if anybody has any questions.
Anybody have questions for Heather? I see your hand. Yeah.
Hi.
Hi, Heather.
Thank you. That was very comprehensive and does sound like a lot of analysis and work. So thank you all so much for doing that. I'm curious about two things, and they're related. One is, it's wonderful that you had the various speakers come in and give some insights to how the programs have worked within our profession, just in different territories, right? Have we looked into what it looks, if it even occurs in any other profession, medical or otherwise, where there is a way to not have an exam to test skills?
You know, we did that. So we brought somebody from the medical board to look at that model, you know, and we hear people who have to do practices like, you know, in a hospital or meet certain criteria in order to become fully licensed. There are no programs that have no a non-exam altogether where, you know, through practice is it. One thing about the medical board that we learned is that despite having like the hands-on practice, there is still a need for an exam. So it's a combination. And even Canada, I think we were anticipating that there were no exams, but almost every one of the provinces had some like at least mini exam or some assessment component. So we really haven't seen any discipline that has a truly non-exam approach.
Because then my second related question was the note that you made about ensuring that it didn't look like a second tier path, and some of the discrepancies and concerns that came up when you talked to the Canadian provinces. And I would just think society in and of itself would create some second tier element to it, because people, for instance, if you're a patient looking for a doctor, you're scrutinizing where'd that doctor go to school, you know, how did they do before I go in? So the same kind of analysis goes in when clients are choosing representation. And I was curious how other regions have addressed kind of that concern that is consumer based, not necessarily coming from peers.
Yeah. Well, it hasn't been addressed really. It's still something that, for example, in our last presentation, Canada is still struggling with. But you know, when I think about how we've done it here in California, if you think about our provisional licensure program, when somebody becomes licensed via this the expanded pathway, so that they wouldn't have to sit for another bar exam. These are folks who applicants who became eligible because they've achieved a 1390 score between July 2015 and July 2020. They were required to work for an extra 300 hours, receive a positive reference, and then they could become fully licensed. Once they become licensed, there is no distinction when they get their bar member and appear on our website. So, you know, I think that's one thing that we could do in California is ensure that we follow that same model, that from the outside looking in, there's no references to whether somebody sat for a bar exam or they didn't. I mean, I think that's when we could combat it. But in terms of what happens in the interim, you know, when somebody's in that supervised practice and not fully serving and not fully licensed, how that looks like, I think that is the challenging part. But I think that shouldn't be a hindrance, because like I said, the PLL model is a good way of looking at, you know, we don't have a clear distinction here at the state bar for applicants.
Well, we have a model of what that looks like in the short term currently, because most students graduate in May and you don't get your bar exam results until November, and you are practicing sort of under supervision. If you're at a firm or something, you're doing discovery or, some drafting under the supervision of a more senior lawyer until you're licensed, on your own. So this just sounds like, I'm not completely familiar with how the provisional system is working, but it sounds like a longer extension of that concept.
Yes, basically. And the only thing is that the PLLs would have like somewhat of guardrails because they've actually sat for an exam and achieved the current cut score, right? So it's a little different in that sense. All right, any other questions or thoughts?
Nope.
Or I think
Shalak, I'm sorry, Shalak, yeah.
It's a tentative hand.
Sorry, I forgot to use the raise hand feature there. I'm wondering, Amy, I listened with curiosity when you were talking a little bit about how this might impact the curriculum of law schools. And has there been any conversation with the ABA for ABA accredited schools, and then conversely the Cal accredited for what this might be? I've seen recently a movement among certain people within the ABA schools to push from the school side towards a non-exam pathway. And I'm wondering if there's been any conversations or presentations from those professors or practitioners, and consideration of the ABA's requirement that if schools are in states where people are taking a bar exam, that graduates pass within 2 years of that graduation. And then of course, how that might impact our Cal accredited schools as well.
So one of the fortunate things that we planned early on is to have representation from all 3 law school types on the Blue Ribbon Commission. So we have deans from each of those law schools as members, and that's been very essential. Even as we were exploring the experiential education component, each have presented on how that works at an ABA law school, at a registered law school, at a accredited law school. So we've definitely had their involvement and had other schools, other members from those school types come and present to the committee. And they've also kept us apprised of whether it's an ABA requirement. And also we obviously know the rules related to the California accredited and registered in light of the experiential training requirements.
Can I ask a related to the topic, but not about the ABA accreditation follow-up? I'm curious if there were to be any, I apologize, if there were to be any, the experiential or supervised pathway, how we might accommodate or recognize that some people would get an unpaid, and the impact that might have financially. So if we put in place any type of, more than just the general experiential requirement, but any type of other requirement that we might have, what would that mean for people who can't afford to take an unpaid position for 3 months, 6 months, etc.? You all may know that there's a labor requirement. So now if a student is doing an internship that's not with potentially a government or registered nonprofit, there's some type of payment is required. Most times I hear from students it's not adequate for their needs and the amount of work they're doing. And I'm concerned about how that might be implicated. And of course, I know you said the commission sort of rejected a couple of these proposals, but I want to make sure that the socioeconomic status of all of our applicants is being taken into consideration. Bar fees are already incredibly high, and prohibitive for many people. And when we add upon that, these other requirements that impact their ability to start being gainfully employed, I just have concerns.
Okay, and Shalak, those concerns have really been expressed by the commission themselves. So very early on, the commission put together a set of guiding principles that they were using as part of what would guide them in their decision making. And equity in the context of cost and to applicants is definitely out there. It's something that we've discussed. even how much a non-exam pathway would cost. Like, would that be equal to an exam? Aside from like, you know, the salary earnings or not, or the lack of salary earnings of those participating under supervised visitation, supervised, what's wrong with me? Supervised practice. So I think that, yes, it's a big consideration. And I think that's really what's at play here. I think it's why it's becoming so challenging to land on a determination because of all of that. You know, there's, you know, it's clear that the group does not want to create any inequities in a non-exam pathway, or have it reflect the inequities that exist in an exam pathway happen in a non-exam. All right. And it looks like, Michael, you have a question.
Yes, thank you for all of this information. I think that a lot of what Shalak said probably is going to be reflected in my question about how the shortfalls that have come up with the provisionally licensed attorney program could be remedied or would be addressed in a non-exam pathway approach. It would be, am I breaking up?
You're okay, Michael.
I'm sorry.
You're okay.
Okay, sorry. So in short, it would be unfortunate for somebody to go to law school with the idea that they were going to pursue a non-exam pathway alternative, only to find out that they couldn't find somebody to supervise them for the requisite number of hours. And I can imagine a situation where it's individuals who traditionally have come from represented backgrounds that are able to make those connections, or that have those connections, and that we wouldn't be adding to the diversity of the profession unless there are guardrails in place before the program is rolled out. And I'm wondering how the commission has thought about that. I understand that there's a lot of moving pieces right now, but I'd be interested in hearing how that's being talked about.
So Michael, that was like, we heard from a few organizations, and it's about, you know, successful programs, even one in California, that partner applicants with an agency where they work while they before they take the bar exam. And even looking at our own program, I think the big consideration is like the consistency in the level of training and oversight that people get, as well as the access itself. You know, one of the Canadian provinces, or maybe it might be two, they actually have a group that's dedicated to looking for these potential employers and for the supervision. And they also provide extensive training to those supervisors to ensure for consistency. And as you can see in one of the in the proposed motion, the first one under supervised practice, one of the call outs was that we have a mandatory and structured supervisor training and oversight that would be developed by the regulator, by the state bar, that's required in order to ensure consistency in that component in a supervised practice. And also to ensure that everybody's getting the same level of skills and abilities tested in that environment. So I think that's one of the safeguards, is that I think hopefully the idea of a supervised practice would implement that kind of consistency. But I still think that it doesn't address the other part, which is access altogether, identifying these employers. I know that one of the things that the state bar did when we first opened the PLL is also offer, and it was through Elizabeth and Juan's office, that offering incentives to employers who are willing to take on a provisionally licensed lawyer. I think we need to find ways of doing that as part of this component to ensure that access is not an issue, and especially access to paid work. So yes, the group is very aware of these, and I think that was implementing that training and supervision and oversight of the supervisors is one way to tackle that.
Thanks, Amy. And I just want to, add, Ryan and I, are both on the Blue Ribbon Commission, and I was actually assigned to the non-exam pathway. And we've talked about this at past meetings, and the concerns that you all shared are the concerns that that Ryan and I share, and they're on both sides, about equity and access and who gets the supervisors and how much they get paid, and the scalability, and can it be offered to everyone? So, you know, these are things that we've been talking about and the commission has been talking about. Shalak.
I just wanted to point out that there's a raised hand among the non-board attendees, and I wasn't sure what the protocol was for acknowledging that.
Yeah, so the public comment part was in the beginning, and so I saw that as well, so thank you. Anybody else have anything they want to ask Amy about? All right, thank you, Amy, so much. Of all of the things that I have done for COAF, and there are many, the amount of work that the Blue Ribbon Commission has put in and the State Bar staff has put in, and all the members of the commission have put in is really astronomical. And so thank you, Amy, for putting this together and being here today, and for all the work that you do and Devin does and everybody else does to make this happen.
No problem, Judge. Thank you so much. Thank you all for being here and for your questions. All right, thank you.
Thanks. Okay, moving on to Lisa on attorney discipline. Are you here, Lisa?
Yes, I am. Hi, good morning, everyone. It's 10 minutes to 12, so I'm still going to say good morning. Hi, I'm Lisa Chavez. I'm the director of the Office of Research and Institutional Accountability, and I'm also the staff coordinator for the Ad Hoc Commission on the Discipline System. This commission was put in place in, seems like just yesterday, but it was really in November 2021. And a commission was formed of 26 people who worked really diligently over the last year to formulate a set of recommendations that are meant to improve both the fairness and the effectiveness of the discipline system. The last time I spoke to you, I shared with you a set of recommendations that the group passed at their June meeting. The group met for a second time yesterday. No, sorry, wait, we're not. 2 days ago, and to pass another set of recommendations, and that's what I'm going to be sharing with you today. So let me get started here with my screen. Oops. Sorry, excuse me. Let me make sure I have my two screens available. And Sarah Good's going to chime in, right, Sarah? Sarah Good was on the committee, and she's going to chime in to give you more context as needed. She was there. Okay, let me just turn to screen sharing. Okay, so just a really big picture again, you know, the purpose of this commission, again, billed by 26 members, was to take inventory of the discipline system reforms that have been taken place in the last several years, evaluate their impact, ask how these policies have their impact, what has been the impact in particular on public protection. And in so doing, they reviewed existing studies, and they also commissioned new studies by my office. And again, the purpose was to recommend additional or revised forms. So before I share with you the last set of recommendations they adopted, let me just review the timeline. Again, they started in April 2021. They worked throughout the year. They here in right in the middle, June 21st and August 24th of this year, that's when they adopted recommendations. Next month at the Board of Trustees, staff will present their final report, which is another thing that they approved 2 days ago, which is their final report. The purpose of the agenda item to the Board of Trustees is for the Board of Trustees to simply receive the report and put the report out for a 60-day public comment. And then in December, the commission will convene for one last time and review any comments that the public has made and consider revising their recommendations in light of those comments. And at that point, staff will then update the Board of Trustees in January if there's any on the public comment, as well as any revised recommendations. And at that point, all of the recommendations for the Board of Trustees from this commission are in the Board of Trustees' hands. Okay, so let me share with you. Okay, so just an FYI, their June meeting, they had adopted a recommendation on progressive discipline, but that recommendation was invalidated because there wasn't a quorum. So they had to redo it again. So that's what they did. So the topic of progressive discipline has to do with two standards that we have at the State Bar. One looks at whether or not standard 1.8 says that if a lawyer has a single prior record of discipline, that the sanction, meaning discipline, must be greater than the previous imposed sanction, unless et cetera, et cetera. And then there's also a standard regarding 1.6 that says a lawyer must establish mitigating circumstances by clear and convincing evidence. So the commission took up this issue because they were concerned about fairness. So one reason why this commission was sorry about my dog. One reason the commission was formed was to consider issues of disparities in racial discrimination that have been established by the state bar. It has been established empirically by the state bar that there are disparities in discipline by race, ethnicity. And so they were concerned that progressive discipline, if we have such a policy in place, prior discipline maybe if prior disciplines are the result of disparities, then a system of progressive discipline then would simply just continuing those disparities. So people made the argument that these two standards should be reconsidered because any changes may help reduce the impact of prior discipline. And also the concern was perhaps changes in standards would allow for greater judicial discretion, and that too would increase fairness. And so this is the exact recommendation that the commission adopted. It says that the commission recommends to the State Board of Trustees that it analyze and modify standards 1.6 and 1.8 to permit the greater exercise of judicial discretion with regards to progressive discipline. Okay, so this is the type of recommendation where a lot of recommendations were just like, we recommend that they're all written that we recommend that the Board of Trustees do X, analyze X, implement Y. So it varies. And then this is an example where it's rather than saying offering language to these different standards, rather than this commission getting into the weeds, they're asking the Board of Trustees, you take on this as a project, analyze and modify it to achieve this goal of permitting greater exercise of judicial discretion with regard to progressive discipline. So that's one recommendation they adopted on Wednesday. Another one has to do with moral turpitude. Now, moral turpitude is a type of misconduct allegation. And it's defined very clearly in the Business Professions Code that says that, excuse me, I can't read my own thing because the Zoom panel is hiding it. Okay. Excuse me for a second. The commission of any act involving moral turpitude, dishonesty, or corruption, whether the act is committed in the course of his relations as an attorney or otherwise, or whether the act is a felony or misdemeanor or not, constitutes a cause for disbarment or suspension. Now, attorneys can be charged with this particular allegation of moral turpitude, whether as an original matter, which is like a complaint filed against them, or when OCTC is transmitting a criminal conviction to the State Bar Court. So members of the Moral Turpitude Working Group discussed the following issues with regards to this particular area of misconduct. One is that some people, especially members who represent attorneys in discipline proceedings, shared that in their opinion, OCTC overcharges this particular allegation. They also shared that their clients experience moral turpitude kind of like a scarlet letter. And so they're really hesitant to settle their cases during an early neutral evaluation conference, which is their opportunity to try to settle a case before it goes to State Bar Court, because that process doesn't really allow them to thoroughly defend themselves. And so therefore, they'll say, no, I need to go to State Bar Court because I don't want this on my record. I'm not going to be convicted of this. I did not do this. So this is like, because again, like to have moral turpitude on their records, they're experiencing it like a quote unquote scarlet letter. Members also shared that in their experience in defending respondents in State Bar Court, as well as during the settlement conferences, that they feel OCTC, our Office of Chief Trial Counsel, has been inconsistent in its willingness to settle cases involving moral turpitude. And finally, some shared that they really feel that OCTC doesn't sufficiently utilize the discretion that it has when evaluating criminal conviction cases to transmit to State Bar Court. So given all of those issues raised, the Moral Turpitude Group adopted they proposed a set of recommendations to the full commission. And what I'm going to do next is share with you the set of recommendations that the commission adopted 2 days ago. Okay. So first has to do with this early neutral evaluation conference. And I just mentioned this. So with the early neutral evaluation conference, this is a conference settlement conference that's held prior to the OCTC filing of an official notice of disciplinary charges. And as I mentioned earlier, like, people on the committee, or two of them in particular, represent respondents during disciplinary proceedings, and they shared the following concerns. They said that OCTC, ultimately the way the process is set up, they're not bound to follow the judge's judicial evaluation of that conference. So when this conference is held, a state bar court gives an assessment of the case. And even if the judge has raised concerns regarding lack of evidence to support a moral turpitude charge, OCTC is not mandated to follow their direction or their evaluation. And second, again, like I shared, the OCTC attorneys, in their opinion, are consistent in their response to these judicial evaluations. Some have been willing to negotiate, and others said, we don't have the authority to negotiate. So they said that this is ultimately an issue of fairness and efficiency. And these members maintain that if more issues would be settled, if the process, that is the ENEC process itself, would be improved, be more explicit about what OCTC can and cannot do, et cetera. And they also feel that if more cases could be settled at this part of the process, it'll be a faster and less expensive resolution for respondents as they go through the process. And so as a result, members put forth this recommendation, and it was adopted by the commission. The Ad Hoc Commission on the Discipline System recommends that the board direct staff to work with stakeholders to propose revisions to all applicable rules to promote the use of the Early Neutral Evaluation Conference as a mechanism for arriving at pre-filing settlements of state bar disciplinary proceedings. Okay. So another recommendation has to do with misdemeanor criminal conviction cases. In particular, the idea that the state bar should establish what's called a pre-transmittal meeting. So here's the background to that. So OCTC must transmit criminal conviction matters, quote, which involves or may not involve moral turpitude within 30 days of receipt to the state bar court. That's in statute. But an analysis by my office showed that most of misdemeanor cases that are recently disposed in state bar court resulted in no disciplinary action, especially those that are based on very old convictions. And right now, there is no mechanism in place, such as an ENC, for these types of criminal conviction matters to be reviewed before transmitting to the court. Members of the moral turpitude said this is an issue for two reasons: for fairness and efficiency. They said, first, respondents incur costs, even if their cases get dismissed. So that is that, so these cases that got transmitted, even though they got dismissed, they still incurring the cost that involve being your case heard in the state bar court. They also, those who choose to hire an attorney, incurred the cost of hiring an attorney only to get that case dismissed. They also noted that cases remain on the state bar court's public docket, even if their matter was dismissed. And they also argued that it's really wasteful to send cases to state bar court that the court will ultimately dismiss. So why not find a way to deal with these cases before sending them to the court that will save state bar court resources and OCTC resources? So the Ad Hoc Commission adopted the following recommendation. The Ad Hoc Commission on Discipline System recommends that the board direct staff to work with stakeholders to study possible revisions to all applicable rules to determine the feasibility of conducting a pre-transmittal meeting similar to an ENEC. And misdemeanor convictions, specify what types of convictions this is going to apply to, that would determine whether or not the facts and circumstances underlying the misdemeanor conviction involve moral turpitude, et cetera, et cetera. I'm so sorry, my dog's barking. It's just for my lunch arrived. Okay, excuse me one moment. Sorry, just had to go close the door. Okay, so there's one more recommendation. Okay, so the next recommendation is the last one, actually has to do with the alternative discipline program. And this is a program where attorneys who are facing discipline in state bar court can be accepted into the alternative discipline program, where they can, upon completion of their program, earn a lower level of discipline. And this typically involves participating in our lawyers assistance program for around 3 years. Now, people involved who are really involved, again, in representing attorneys in state bar court matters, noted that there's 2 rules that guide eligibility, as well as other types of that guide eligibility for this program, and they say that they're in conflict. So the first rule here just says who becomes ineligible, but the second rule here, 5.82, says participation is contingent upon the court's approval of a stipulation, which is basically an agreement. And so they note that the latter rule effectively disallows participation because if parties can't agree on whether or not there was a misconduct, then a stipulation can't be reached. And so they said that this is an issue of fairness because ultimately the state bar court, the state bar is really directed as directed by Business and Professions Code 6230, that the state bar should be seeking ways and means to identify and rehabilitate attorneys. And so they really feel that clarifying these rules will increase participation. And so they put forth the following recommendation, and it was adopted by the commission 2 days ago. And it says the Ad Hoc Commission on the Discipline System recommends that the board direct staff to work with stakeholders to study and clarify all applicable rules involving referrals to the ADP program, specifically concerning whether or not moral turpitude has resulted in significant harm to clients or administration of justice. So as you can see, this set of recommendations, in contrast to the previous ones, really are directing the board to work with staff. So it's not telling them, thank goodness, to form like another working group or another commission. It's more like direct staff to work with different stakeholders to really understand the issues and present to them a proposal for a solution. And again, each recommendation really makes it clear what solution you're trying to drive towards. Okay. I think that's all I have. That is. Sarah, do you want to chime in at any point right now? Sarah Good was on the commission.
No, I thought that was an excellent summary, Lisa, and I have nothing to add unless somebody has questions for me. So thanks, Lisa, for all of your hard work with the Ad Hoc Commission, and for Justin, who worked with us for so long tirelessly as well.
Thanks. Thank you.
That was
any questions?
Yeah, super thorough. Lisa, thank you. And thank you, Sarah, as well, for all the work that you're doing on this. It's super important work. Anybody have questions for Sarah or Lisa? All right, seeing none. Am I missing anybody? I don't see any. Is Carolina on? Or Meryl?
Carolina and Meryl are on.
Okay. The diversity report card.
All right, good afternoon. It's 12:04. Okay, great. And then okay, great. All right, my name is Carolina Amarante. I'm an analyst for the Office of Research and Institutional Accountability, RIA. And forgive me, I'm going to be looking sort of two sides because I have two screens during this presentation. But the first is to say that we are incredibly excited to have published the report card on diversity of the legal profession. And again, want to thank many of the members of the committee who were involved in supporting this work. It's a really exciting time to display this, to share this information out. One, because of the calls to action, which will be talked about later, but also how the information is displayed in the report. You can do some deep dives with interactive components of the report to really look at how the profession, the diversity of the profession is modified, changes through different sectors. Okay, next slide, please. So just very high level, what is the attorney census? And so the diversity report card, the data that's being reported to the diversity report card was collected through the attorney census, and that is a voluntary survey that captured demographic and employment information from attorneys. We had data on active attorneys in the report, and we collect in the census data on race, ethnicity, gender identity, transgender, sexual orientation, veteran, and attorneys with disabilities. And this data is collected across the different sectors. Next slide, please. So very high level, in the report, we provide information on the 2022 attorney population, and then we provide similar information for 2021 attorney population with employment data. So we'll talk solely right now on the 2022 attorney population. Similar trends that we saw in the previous report card that was published in 2020, which highlighted that a majority of the profession is white attorneys. And so white white people comprise 39% of the state's adult population, yet are 66% of California's active licensed attorneys. When looking at the chart on the left, you'll see that the chart shows the California's adult population compared with California's 2022 attorney population, looking at the white population versus people of color. And to the chart on your right, you will see California's adult population compared with California's 2022 attorney population, looking at the breakdown of race ethnicity. And as it was mentioned in the title there, you do see a larger representation of white attorneys. The highest gap in terms of disparity gap for representation is noted for the Hispanic and Latino population, where you have 36% are represented in the state population, but 6% in the profession. Next slide, please. We also have data disaggregated by the intersection of race, ethnicity, and gender identity. So here we're looking at gender identity and race ethnicity in the comparison of white men, white women, men of color, and women of color. And so you note that white men comprise the largest group of California attorneys, and the next largest group is white women at 26%, followed by women of color 18%, and men of color 16%. And you can get this information for your sector going into the online report with the interactive charts. Next slide, please. Further on gender identity, we collect information on gender identity, including transgender populations. And we did a comparison to the California adult population, where you would see on the left-hand side, 51% are women, 49% are men. And the California attorney population is slightly different, where 44% are women and 55% are men and 1% non-binary. And for the transgender population, we're continuing to improve our data collection practices and collect information on transgender attorneys who identify as transgender and compare that to the California adult population. So here you see 49% noted in the 0.49% for the California adult population, and then 0.26% for the 2022 California attorney population. Next slide. Similarly, we collect information on sexual orientation, veteran, and people with disabilities. So in comparison to the California adult population, to the California attorney population, we are underrepresented in terms of attorneys with disabilities, where 23% identify, 23% of California adult population identify as having a disability, where only 6% identify within the California attorney population. Next slide. Similar, the share of attorneys identifying as LGBTQI+ is the same as California statewide adult population, and with respect to that same group. That trend, this number has recently increased from the data that we collected on the California adult population side. And looks like there might be a bit of a typo, my apologies. There's a similar trend for veterans for the presence of attorneys. So for veterans, it's about 5% for both California adult population and California attorney population. Slide. We also track diversity and demographic groups for newly admitted. So for the newest cohorts of the profession, we found that this is the most diverse from prior years. And while there was a small drop in the number of admitted into the profession due to COVID, we saw those numbers increase for women and people of color in 2021. Next slide. Okay, great. So this is where we transition to the 2021 employment data. And the report has really great interactive slides where you can select your different demographic group by your sector and see how these percentages change. And so what are we seeing here? So on the left-hand side, the way to read the chart for primary employment sector for California attorneys is you look at the specific demographic group of interest, and then for that demographic group, what is the percentage of those of those in that group across the different sectors. So the first bar is total 2021 California attorneys. We see here that a majority are in the private sector. How does that compare for those that are identified as white attorneys, attorneys of color, men, women, non-binary, transgender, and then LGBTQIA+, attorneys with disabilities and veterans. So a lot of great information there that you can compare within your own sector. And so we know that for the most part, majority of attorneys are working in the private sector. The highest proportion are law firms, then those in civil practitioner, and then in corporate settings. And majority of those that are working in the private sector are white and male attorneys. Next slide, please. So this is a different way of looking at the data. So now we're saying, okay, in each specific sector, what is the demographic? In the prior slide, we're saying, okay, how does the experience change for each demographic group? Now we're saying, how does it look if you just focus on one sector? So if we were to look at law firms, the way I read the charts for law firms, 42% are white male, and then it moves into 26 are white women, and then you have white non-binary. So the top first portion of the bars are for attorneys of color, percentages for attorneys of color. So as you read from left to right, you see the attorneys of color bar increase, and that brings the point that the public and nonprofit sectors are the most diverse. Next slide, please. So one thing that we were also able to capture in the attorney census is getting more information on demographic representation, not only in the sectors, but specifically in leadership roles across different sectors. So this is a new data point that we're really excited to report out on. And so when looking at executive leadership across all sectors, we're noticed that women of color are underrepresented amongst executives. And since law firms, a large portion of attorneys work in law firm settings, we're just highlighting here that, that women of color comprise of 16% of those who work in law firms, so only 9% in executive roles. And again, you can go into the online report and look at this for your specific sector. Next slide, please. So going a little bit further on understanding sort of what is the demographic representation in leadership, and then looking specifically in law firms, we asked the question regarding those attorneys who are in partners and shareholder positions. And so the left-hand chart shows demographic representation among law firm partners and shareholders. And the first bar is total attorneys in law firms. So looking at 41%, that's white men are working in law firms. When you compare to that in partners and shareholder positions, they're 55%. And then for attorneys of color, they're 31% in law firms, but only 23% are in partners and shareholder roles. And sort of, going into this a little bit deeper, the right-hand chart, similar to the previous visuals, you look at each individual group and say, okay, what is their experience? And so when we look at the type of law firm partner shareholder by demographic group, so equity, we'll focus on equity for this topic here, you'll see that white men are 77%, I'm sorry, of white men have a equity type partner shareholder position, but that percentage decreases for men of color, women of color, and non-binary attorneys of color. And next slide, please. We also collect information on workplace satisfaction. So there's 15 factors that we asked attorneys to rate their level of satisfaction. And we created these composites of individual, collective, and forgive me, not able to see the last one here. Work-life balance. So for the individual career, an example of one of the factors would be like mentoring and advancement opportunities. And for collective workplace would be the diversity, how satisfied with the diversity of your office, your ability to collaborate with your colleagues. And work-life balance would be an example of family, work, life, of autonomy in your work and work-life balance in terms of your time and family duties. So we found that across all factors, the lowest satisfaction levels were reported by attorneys who identify as non-binary, both white and of color. And the second group would be attorneys who identify with disabilities, and then women of color. And the satisfaction gap between white men and women of color is largest in workplace experiences related to individual careers. So just to carry a little further on that point, if you go to the next slide. Sorry. We'll just stay on this point. So I thought we had a second slide, sorry about that. On this point, we do look at disparity gaps in experience in the workplace factors. And what we learned is that for benefits, compensation and benefits and advancement, pathways for advancement opportunities, we saw the largest gap between white men and women of color. And so we'll continue to look at this, this data to report out in future analysis. But again, I encourage everyone to please go into the report, use the interactive features, and see how this this data sort of changes within your sector. And then for the next slide, I will hand this over to Meryl.
Great, thank you. My name is Meryl Friedman, and I'm a program analyst with the Office of Access and Inclusion. As you may remember, staff have also been working on the calls to action section of the diversity report card for a while. The process started with our staff into DEI best practices to think through what different sectors might need as resources to strengthen their DEI work. The working group gave advice, as did attendees at the last diversity summit. We ended up organizing the calls to actions in two ways: by audience, employers versus individuals, and by sector, to have calls to action for the private, public, and nonprofit sectors. Next slide, please. For employers, we broke down the calls to actions into 4 separate categories. Promote transparency and accountability, address steps like collecting demographic data and cultivating a workplace that encourages voluntary self-identification. It highlighted the importance of creating a DEI plan in conjunction with an expert in staff opinions. And lastly, it encouraged reviewing and evaluating salary and compensation tables with equity in mind. Building an inclusive workplace focus on developing and maintaining an inclusive, equitable, and active culture. It encouraged DEI work and learning. And diversify recruitment strategies focus on ways to ensure the hiring process at every step was inclusive and equitable. And then retaining, advancing, and empowering staff highlighted ways to increase benefits and resources for staff that would cultivate their sense of belonging and satisfaction. It encouraged adopting ways to establish work-life balance and wellness. Next slide, please. The attorney's calls to action echoed the employer calls to actions, but put more of an emphasis on individual acts, ways to advocate for yourself and for others. It also included ways to assess their employer's resources and actions and take proactive steps to make that change. Next slide, please. So at the end of the diversity report card online, there is a page dedicated to the calls to action. On this page, we have global calls to actions for all employers and employees. This is kind of a consolidated list of all of the most high-level calls to action broken up into the 4 categories we discussed. Below this, there are then links to separate PDFs for employers in each sector and 1 PDF for employees. And the next slide will just kind of show you at a glance what those 4 look like. The PDFs can be exported and used as a reference by all employers and employees, and we hope that they'll do that, and they include a set of resources and links that will link them up with even further resources. And that's all about the calls to action.
Thanks, Meryl. Thanks, Carolina. And I also wanted to thank our working group who helped us with the calls to action. I believe that was Michael, Heather, and Sarah. So thank you for that. We're really excited about it. If we are also, if your organization or affinity group that you're a part of is interested in data, specific data or a presentation, we really encourage you to reach out to the State Bar. As we have a lot of data and we really want to share it with the legal community. So please let us know. Judge Kristen had to step away. So if there are any questions, I can help field those right now. Sarah?
I had one question. I kind of vaguely remember that there were some questions in the survey related to pandemic working conditions and that kind of thing. And I remember, but maybe I'm wrong, that it was going to get rolled into this one. Can you kind of refresh my recollection or update us on that?
Yeah, so we did, Sarah, you are remembering correctly. We did survey attorneys on the impact of 2020. So the pandemic, the first year of the pandemic, as well as the increased discourse on racial justice issues. And so there are some pop-out boxes in the report card that kind of highlight the data that we found there that kind of supplements particularly kind of that last set of data that Carolina presented on related to satisfaction. Heather?
It looks so great. I'm so impressed, even though I've been part of it, like seeing it all pulled together, like this is incredible. And I was not aware that you all were offering to do the roadshow piece of it, to share this data out to organizations, both it sounds like, firms and corporations, but also have you thought about presenting at some of the legal conferences like CMCP or the like Langston Bar or any of those here that we can help ensure gets this information in front of those organizations so people can then share it back to their respective.
Yeah, so we've already received some requests from some affinity bar associations to provide specific data and to make presentations. And so if your networks have an interest, please feel free to reach out and we can coordinate that.
And I'm asking both like presenting to their boards or their leadership, but also presenting at their conferences to the broader membership. Are you all open for both?
Yeah.
Okay, thank you.
Yes, I was just going to add, this might be, and I think they still have proposals available, a great presentation at AALS, the American Association of Law Schools. And I think that would tie really well into the update we heard about law student retention, and to present at a much broader level, the impact of that law school retention on the attorney population. And while the calls for action aren't necessarily for law schools, I think they could see some real synergies there and think about how their alumni networks, the people we bring to OCI, all of that. I'm sorry, y'all know this is my lens. So, but just thinking about different ways that this really crucial information can get out there, that the State Bar can get applause for all of the hard work you're doing and more eyes on it, but also that it can be used. And I think it might be particularly salient because this is the first conference after the ABA requirement has been put in and will go into place next fall. And the conference is in San Diego in January. I'm happy to coordinate with you, Elizabeth, or with Meryl, if you want to think that through more and see if there's any opportunities there.
That would be great. Thank you. Okay. If there are no more questions or comments about this last item, that was our last item on our agenda. So I think we can adjourn.
And just want to echo Heather's comments that it looks fantastic. So just super impressive. And I don't think there's any other state bar that's doing anything close to this. So congratulations.
Thank you. Thank you. We are very excited about it, and we hope that you'll share the link to the report with all of your networks. And, tap us on the shoulder if you want us to come talk more about it.
I just want to weigh in and say the same thing, because I know there aren't other state bars doing this, because I've looked for other state bar reports and to compare. And the ABA's report, for instance, says things like there is no comprehensive data on LGBTQIA attorneys that exists. So the fact that they say there just is no data and we have comprehensive data broken down by industry and demographics is really impressive and important. And I so appreciate all of the work that the state bar staff has done putting this together and getting it out there. So kudos to you and thank you.
Great. Thank you, everybody. Have a good afternoon.